Great. Okay, thank you everybody for your patience as we get started and make sure that everybody can hear us and see our screen. Thank you all for joining us today. I want to take a moment to introduce myself and my esteemed colleague who joins me today. My name is Kirsten Phelps. I am Director of Legal and Social Services at the Tahirih Justice Center, and I'll let my colleague Renee introduce herself.
Hi, my name is Renee Kellum-Mason. I'm the Chief of Programs here at the Tahirih Justice Center.
It looks like we have about 100 folks on the call today on this webinar, which is really exciting, and we're so glad to join with you today to discuss the matter of AB, give some background on this decision that came out last week, and start conversations about legal strategies and practice pointers in light of that decision and what it might mean, particularly for your domestic violence-based asylum claims, but also certainly in looking at any of your private actor asylum claims that you may be working on. We are recording this webinar, so you will receive a link to the recording that will be on our Pro Bono e-library if you need to view it again, as well as if you have any colleagues that were unable to join us and want to view it. There will be a brief survey you will receive at the conclusion of the webinar, so we strongly encourage you and ask that you please fill that out. It's a very brief survey, and it helps us make sure that we are providing the best possible information and support to you all as pro bono attorneys. Finally, if you have any questions during our presentation, we will do our best to answer them in our brief hour together. Please type them into the chat function on GoToWebinar. We will see those, and we will incorporate and answer as many questions as we can throughout the presentation. Certainly, if you have any questions after this presentation as well, feel free to reach out to your Tahirih mentor attorney or to Renee or I directly with any questions that you have. So with that, today we are going to go over briefly the background of the decision matter of AB from last week, including a synopsis, and then move into some strategies and practice pointers for your cases. With that, I'll turn it over to Renee.
Hi, everyone. It's so great to have you all on the line. So last week on June 11th, Attorney General Jeff Sessions issued a decision in matter of AB concerning the application for asylum of a woman from El Salvador who had been raped, abused, and nearly killed by her husband. What matter of AB actually did two things. It overturned a Board of Immigration Appeals decision in Ms. AB's case that was in favor of granting her asylum. It also overturned the board's 2014 precedent-setting decision in matter of ARCG, which also was a DV asylum case that allowed for a particular social group around DV. So what we want to do is go over, there's a lot of, I think, myths and facts when it comes to AB. So we want to go over what AB does, what we know, and what AB, in our opinion, does not do. And then we'll go into legal strategies and thought processes. And what I will, and we'll probably say more than once during this call, point out is that this is a very dynamic moment for all of us, and it's going to take all of our legal minds to come up with new strategies. And at this point, all creativity is welcome and needed. So, but we'll tell you what we think and where we're at, and we'll look forward to hearing where others are at. So, AB strictly overturns ARCG and all other opinions inconsistent with the analysis in the opinion. It has substantial dicta attempting to restrict asylum eligibility for domestic violence victims and victims of persecution by non-state actors. It signals to immigration judges and officers to make adverse credibility findings or discount or give limited weight to country conditions evidence. And also, there's significant dicta around assuming relocation within a country is possible. So, and what I will also flag is the decision focuses on domestic violence cases in AB and ARCG. However, it could be read and can be read to be that the ruling can be read to be broad enough for anyone who has suffered persecution at the hands of a private actor. It wrongly states where the persecutor is a non-state actor, the harm must be attributed to the government. That is a much higher standard than what is in line with the legal standards set by the courts, which requires the government to be unwilling or unable to control the persecutor. And it also demonstrates a complete lack of understanding of the social dynamics of domestic violence, saying merely, and we'll talk a lot more about this, the mere fact that a country may have problems effectively policing certain crimes, such as domestic violence or gang violence, or that certain populations are more likely to be victims of crime cannot itself establish an asylum claim. So what else we know is that yesterday in the press, we all received a leaked guidance from USCIS to asylum officers. And in that, there's a glimmer of, I'll start with the glimmer of hope and then I will go to the rest. The glimmer of hope is that it appears that USCIS is reading matter of AB very strictly and narrowly. However, there are parts of the guidance that everyone should be aware of, and it's right now what we have to go on as to how we might see the government implementing matter of AB. And so on this slide, you'll see one, the link to the leaked guidance, and the other is the underlined sections are the parts that are most concerning to us. And the first is that USCIS is embracing the piece, the statement in the decision that I just quoted, and states that an applicant must show that the government condoned the behavior or demonstrated a complete helplessness to protect the victim. That is a much higher standard, we would say, and would be something, and we will talk more about, that you're going to have to argue against. As well, it goes on to state that every asylum decision and credible fear, reasonable fear screening determination must consider and analyze whether internal relocation is reasonable. And so, again, we want to highlight this, and we'll touch on this later. It's going to be very important in all of your briefs and analysis that you are looking at internal relocation and arguing why it is not possible. So what AB does not, what does AB not do? So despite the dicta, AB does not and cannot change existing asylum law, regulations, or precedent law beyond ARCG. It does not change the requirements for a particular social group. It doesn't touch other grounds for asylum. And it doesn't change the statutory standard for failure of state protection. So the AG claims that prior judicial interpretations of the phrase particular social group are not relevant because Congress in the must have left particular social group ambiguous so that the implementing agency could interpret it. This is wrong, and what we would say is that Congress incorporated into the statute the exact language from the international treaty governing the issue, and we, all of us, are going to have to argue sections around international law and the purpose behind particular social group when we're putting together our briefs. And so we'll talk, so now I think we'll dive into some other arguments that you can make around AB. I think there are a lot of holes that you can poke in AB, and so we wanted to highlight just a couple. And whether or not you use this in your brief will be up to you. Whether you want to put a section that talks about the holes in AB just to preserve the record so that on appeal, maybe something you choose to do. And so we want to go over some of the holes that we see. There probably are a lot more that we're not going to touch on today, but we'll go over a few. So first is a jurisdictional argument against the application of AB. And that argument is that the AG did not have the jurisdiction to certify the case to himself or to decide the case because it wasn't ripe for his consideration. And that's because the case had already been decided by the Board of Immigration Appeals and remanded to the immigration judge for consideration. And when the AG certified it to himself, it was taking it from at that stage of the case. Another example is that the AG states without citation in his introduction that in order for an applicant to demonstrate that her government could not or would not protect her from persecution, she must show that the harm can be attributed to the government, which we just talked about a few minutes ago. That precept has no basis in law. Again, the standard is unwilling or unable. The government is unwilling or unable to protect her, and that would be your argument against that as well. So now we'll turn to some more asylum case strategies for your consideration.
Sure. So thank you, Renee. So now that we have a bit of a background in what matter of AB did, attempted to do, and perhaps did not do, or attempted to do in dicta, and some procedural arguments should you want to brief and argue against the application of matter of AB or the illegitimacy of matter of AB, let's get to the heart of how can we approach our domestic violence-based asylum cases that for the last few years may have fallen squarely within or on the margins of ARCG, and where that precedent that has been directly overturned, we no longer can directly cite to and say to our judges or our asylum officers, grant this because it falls squarely within matter of ARCG, and we have precedent laws saying upholding our position. We don't have ARCG anymore, but we do have a lot of other options, so don't give up hope. It may be more difficult now than it's been for the past few years, but it is not impossible to litigate these cases. And the strategies we want to talk about generally here, again, to Renee's point, this is a dynamic situation. We have over 100 individuals on this call. You all are brilliant minds, and you may think of things that we don't think of, or things that are applicable in your case and arguments that you can make in your case versus other folks' cases. So be creative, be bold, and pursue all options. We want to look here how to continue to argue domestic violence and gender-rooted particular social groups despite matter of AB, and then look at other statutory grounds for asylum, particularly political opinion and religion, but also potentially where you might have race-based or national origin-based claims for your clients. So when we are talking about domestic violence and particular social groups, our thought process behind this is persist in the arguments that you probably were going to make anyways, but expand and go beyond your default particular social groups that you might have had in a matter of ARCG. So for anybody on the call that litigated a case before summer of 2014, you were doing this already anyways, right? And perhaps depending on your judge or the court that you were in and how easily those triers of fact were persuaded by the weight of ARCG and the boundaries of which they were willing to apply it, you're likely arguing a lot of other things in addition to just citing to matter of ARCG. So continue to do that. Now it is more important than ever. And so when we say that, what we mean is present your social groups, such as the nationality, let's say Guatemalan women who are unable to leave their marriage or to leave their domestic relationship. That was the ARCG group, but that was also presented years and years before and proposed by DHS themselves in the matter of RA brief that they wrote. And we've got a cite on the slides here. So argue that formulation and read that brief. It does an excellent job of laying out the framework for how the social group of a Guatemalan or Salvadoran or whatever nationality woman who's unable to leave their marriage or relationship meets all of the requirements of cognizability for a particular social group. So argue it despite the fact that ARCG has been vacated and overturned, because the dicta behind the decision in AB says these groups are just illegitimate and shouldn't be applied, but it can't actually change a judge's responsibility and the lawyer doing their job of applying your client's facts to the law and proposing the social groups that you think meet legal muster. The other domestic traditional, sort of old school domestic violence particular social group that we have argued for years and that we'd never had precedent decision on, but was accepted by many triers of facts in the asylum office and in various immigration courts, is women viewed as property by virtue of their position in a domestic relationship, plus nationality. And you can go through that framework in, again, a social group that DHS themselves said, we think this is a social group that meets the cognizability tests as articulated in the statute and case law. And that was in no way overturned or touched really by AB other than in indirect dicta. So both of those briefs are available at CGRS website, which is on the slides. So that is the persist half of the advice. The expand is where we want to think boldly and creatively, and now is the time to put anything forward that you think you reasonably can put forward. Whereas until last week, for the past few years, you might have had a judge where you knew they were strongly on board with ARCG and you had facts that fit nicely within or nicely or very adjacent to ARCG, and so you argued and briefed in a pretty streamlined fashion your ARCG social group, got a grant, and life was wonderful. And while we hope something like that can still happen in the future, now is the time to put our lawyer hats on and think outside the box and push the envelope, as lawyers did for 20 to 30 years before ARCG to get us to that point. So we are back in those times where we litigate and where we are creative and we push. And so a few possibilities to consider. Again, here this is an area where you may come up with formulations relevant to your cases that aren't on this list. So it's not an exclusive list. But we want to start with the very basic gender plus nationality. A Guatemalan woman, right? A woman in Salvadoran society. That meets particularity, that meets immutable traits, that is socially distinct, that is a cognizable social group. So don't conflate it with the question of nexus, right? If you have facts that show that your client's abuser abused her because she was a woman in Guatemalan society, then I would posit that you have a cognizable social group, your client is clearly a member of that social group, and your client has been persecuted in part, or at least one central reason, because of her membership in that social group. You still have to do your analysis on internal relocation, state protection, all of those other grounds, but don't muddy the waters with what is a social group, just because, frankly, the Attorney General did that in the matter of AB decision. So go back to basics with your cases. Another idea, and there's a question mark here because perhaps it doesn't pass the test, but maybe it does in your case, is a Guatemalan mother in your client's case. Is that a social group that applies, that's cognizable, and that she's a member of, and that there's nexus to the persecution? So think boldly and outside the box. Another area to explore specifically is family membership or kinship type particular social groups. There's extensive case law out there on family member particular social group cases. We have here a few in the Fourth Circuit, but it's not exclusive to the Fourth Circuit. So find the case law in your own circuits if you're elsewhere in the country on cases where your client is perhaps persecuted because she is the mother or the sister or the wife of a person, and that family relationship, being in that family relationship, it renders them the target for persecution. So if you're in the Fourth Circuit, or if you want to use it as additional persuasive case law in other circuits, you have Crespin Valladares and Hernandez-Avalos. You do have a difficult decision in the Fourth Circuit, Velasquez v. Sessions, that came out this year that denied asylum, but I think it's important that you distinguish and look at your case. In Velasquez, really, it came down to the court interpreting the persecution of a mother by in-laws, essentially, as being part of an intrafamilial custody dispute. So a truly sort of personal family matter, and not the context of you are a mother or you are a wife in this country, and therefore you are being persecuted because you are being viewed as part of this group. So I see that we do have a few more questions, and so we will try to get to those as soon as we can. We see some questions about going back to state protection and what AB does and doesn't do. So we will get to that question very soon. So again, on our particular social groups, the bottom line is that AB, the way we have read it, is that it attempts to really fundamentally change or shut down whole categories of social group formulations, but that it cannot, and in fact, it should not, and in fact cannot change the statutory requirements of what is a cognizable social group. And there are some variances in case law among the circuits that you're going to cite to, but at the most basic, you're looking at matter of acosta for immutability. You're looking at, is your social group particular? Is there clear benchmarks of who's in and who's out? And argue that the point that just because it's particular doesn't mean the social group has to be small. There is lots of discussion of that in case law throughout the circuits, and I think that's really an area where the AB decision tries to muddy the waters there, and say that, well, it can't be particular because we're talking about huge groups of people in a society. That's not what existing law says. Particularity means, is there a way to define who's in or who's out of the group, not the size of the group itself. And then you'll want to make sure that your social group is socially distinct. So you'll want to look to the companion BIA cases of MEVG and WGR that came out in 2014 around the time of matter of ARCG to go through your social distinction analysis. So I've said this before, but I'll say it again because I think this is really a moment, and I know for myself, this is why I wanted to be a lawyer. I wanted to make arguments and push the ball forward. So be creative, be bold, and throw in the non-frivolous kitchen sink. Obviously, don't throw in social group formulations or claims that are not supported by your facts, but dig into your facts and see where you can push beyond what might have been a default to matter of ARCG arguments. But then don't stop just at particular social group. When we talk about gender-based asylum claims, many of us that have been in this field, we almost instinctively go straight to particular social group because that's where the jurisprudence has been for a lot of valid reasons. But when we're talking about domestic violence and the lived experience of your clients, let's unpack what they're actually experiencing, what they're actually saying and doing, and what their abusers and others in the community are saying and doing around their experience in abusive relationships. Because oftentimes, as you dig beneath the surface and unpack the layers, you will find political opinion-based arguments, religion-based arguments, as well as potentially national origin or race arguments. So very briefly, when we talk about political opinion, it's important that we open up the blinders that political opinion asylum claims are not just for activists marching in the streets and political dissidents or opposition political parties. There is case law that says things like holding feminist beliefs or being a feminist is a political opinion. There's great case law out of the Fourth Circuit, so keep looking in other circuits for similar case law that expressing a political opinion can be done through symbolic or less overt acts, such as refusal to comply with norms or to resist, oppressive norms that you disagree with. And in my experience working with domestic violence survivors, that is exactly what they're doing on a daily basis in an abusive situation, right? So when you're talking with your clients and trying to get all the facts, dig in to see what were her views on her right to work, what were her abusers and the family and the community's member on her right to work or not work, economic independence and autonomy questions. Was she pro-choice? Was she pro-life? And how did that play out in the dynamics of her relationship and her reproductive choices or lack of choices? What were the views, hers and her abusers and others, about education, the rights of her to get an education, or her daughters versus her sons? A lot of that can be there, and you can see where there's violence that is escalated and enforced directly in response to exerting symbolically or overtly political opinions about this. And so it's really important to thoroughly interview your clients, to really build that rapport and get beyond just the surface level of, well, he beat me, or he'd get really angry and come home and sexually assault me. That's important, but dig beneath the surface too. And if you'd like some more tips on how to do that, hopefully you have received our invitation to next week's webinar on trauma-informed interviewing to help get you those facts that you need. Moving on to religion, we have, you want to be looking at religion not just in the context of, is this a Christian woman in a Muslim society or a Muslim woman in a Christian society, but look at how does your client, if they have religious or faith beliefs, how does she express them? What is her interpretation of them? Does it differ from her abuser? Is her abuser of the same religion, and even if he is from the same religion, does he adopt a different interpretation of it? Other questions I would look at is, did your client, who is a domestic violence survivor, go to her church and try to seek help or advice, or to get help getting out of it? And were they rejected by their faith leader or by their pastor? I think if you have facts like that, you can really start to craft an argument of, was she in fact persecuted and subjected to this domestic violence, sexual assault, torture in her own home because of her religious beliefs, right? I see this oftentimes. I've seen this in cases where you may be able to tease out religious-based arguments where you see, again, reproductive questions, reproductive health questions. So forced pregnancies or forced abortions and terminations of pregnancies, or attempts to force a miscarriage, right? And does your client have religious beliefs that conflict or differ from her abuser as to her reproductive rights, wherever they fall, right, as to her reproductive health? So that's the kind of facts you might want to think about teasing out. We include one case citation here that I think is really helpful in breaking out of the box of thinking, breaking out of the blinders of thinking of one religion versus another religion as the basis for persecution. It's Matter of SA. It's a great Board of Immigration Appeals decision from 2000, where it was a daughter who had more liberal or progressive interpretations of her Muslim faith than her father. And so she sort of refused to conform to his religious beliefs, and he abused her because of that. And it was a grant and a precedent and a decision from the board that has really great language that I encourage you to look at. And then very quickly, before I turn it back to Renee, also don't overlook race or national origin. It's not always the first thing we think of in these cases, but particularly with Central American survivors, is she indigenous with an abuser who is not indigenous? is in a mixed race relationship. You have communities of African descent in Central America and Mexico and the Caribbean, where a lot of our asylum seekers are coming from. So don't assume there's not a race or national origin claim there as well. It's worth asking the questions.
So I want to start, we're going to go to other practice pointers, but I want to start with unpacking a little bit more the state action or inaction. I believe that was one of the questions, and I realized we forgot.
Lots of questions.
Well, we'll work through the questions, yep. But I realized it was a slide we forgot to put in. So I think it's important to look at, when we talk about unpacking that, and you know, there are arguments that you can make based on the law itself on what does the law say about unwilling or unable to protect, and distinguishing that from the dicta in matter of AB. But I'm going to go a little further and say, look at we think that there's an argument to be made to look at the whole system in a country. For example, when you look at the U.S., and I'll say that because he uses the U.S. as an example in matter of ABs to minimize the issue of individuals fleeing for fear of domestic violence, and so we'll use the U.S. as an example. So he states, like, if the police don't respond to a call in the U.S., it's not that we're discounting the gravity of that crime. So I'll start with, and Kirsten can add in as well, but I'll start with, if we look at the U.S. as a whole, we have a whole of government approach to combating domestic violence in the U.S. We have federal money that goes to combating domestic violence. We have, for example, even at the Department of Homeland Security, they have a Council on Combating Violence Against Women. We have a national hotline. So there's all these resources that we as the U.S. government and as the U.S. society are putting in and focusing on domestic violence. So when you look at other countries, you can look at what is the response of the government and the whole of government to domestic violence, and make those arguments that even though there may be a law on the books, is it really being enforced? And if it is being enforced in certain areas but not in others, you're going to want to make those arguments. Right. Do you want to add?
Yeah, I'll add to that too. I think because we see this a lot, and the dicta and the discussion in matter of AB really does minimize and attempt to sweep under the rug the very real differences between a country that is actively and assertively confronting its violence against women or its gender-based violence epidemic, but not able to, of course, arrest or prosecute every abuser and prevent every single incident of domestic abuse from happening, and those that have passed a law at the federal level and done nothing to implement it, and there's no accountability and there's impunity. For example, the United States, in every jurisdiction in the United States, there is some sort of a protective order law and a court and a process, and there is full faith and credit throughout the United States, so it can be enforced anywhere. So look at the country that your client is coming from. Is there anything remotely like that? Are there any shelters? Or is there just a piece of legislation that was signed and rubber stamped by, you know, the federal government with no implementation structure whatsoever? I think that is a way to combat against matter of AB's really frustrating dicta. That and to one of the questions that we got about the matter of AB says you've got to attribute the persecution to the government, or show as the USCIS leaked memo says, utter helplessness, right? The standard is unable or unwilling to help. Like, that is very clear. And so what they're trying to do is ratchet up what that means. But as advocates and attorneys, we are the ones fighting back against that, to say utter helplessness does not mean that no police officer never arrives on the scene, or that they say, no, we will not even show up to report. A common fact pattern is, I called the police, they showed up, they said, well, you don't have any bruises, or they wrote a few things down, and then I could never find out again whatever happened to anything, and nothing happened, right? Or I went to court and nothing happened. So don't minimize, don't do the work for your opposing counsel of saying, like, you know, of minimizing the fact that, you know, yes, she called the police or didn't call the police, and so therefore we can't show that the government, that she can't meet the standard. This is where we have to argue back. And I frankly, I would really encourage doing like a compare and contrast between countries that have a system in place, and while they don't have 100% prosecution and conviction, they have a system in place, right? Survivors know that they can call a hotline, they can get into a shelter, they can get a protective order. And that is not the case in a lot of like Central American countries and other places that your clients are coming from.
Okay, I'm going to move on to some other practice pointers, and then we will continue going through your questions and respond to them. So some other practice pointers to look at is, so I think we have to look globally as well. Matter of AB, unfortunately, is not the only precedent case that has come out in the past 6 months from the Department of Justice. And so please be aware of 2 other precedent cases that have come out and what they may mean and what you need to do as you prepare your cases. So the first is matter of WYC and HOB, which states, and I'll just, and again, I think we need to read, and I was reminded yesterday as well, we should read things narrowly. And so I'm going to tell you what the holding is, and then I think there's lots of ways that you can argue it. So, but important to know that in matter of WYC, it states that an applicant seeking asylum or withholding of removal based on membership in a particular social group must clearly indicate on the record before the immigration judge the exact delineation of any proposed particular social group. And that the Board of Immigration Appeals generally will not address a newly articulated particular social group that was not advanced before the immigration judge. And so we want to highlight that because it goes back to what Kristen said about throwing in the non-frivolous kitchen sink. You know, given WYC, it's even more important, especially as attorneys when we're representing individuals in immigration court, that we have thought through thoroughly all particular social groups, and we're presenting them along with all relevant facts that support those particular social groups when we're presenting the case in chief in court. So the other case to mention is a matter of EFHL. And so for this, it's an interesting case history for matter of EFHL. So matter of EFHL was a precedent case out of the Board of Immigration Appeals. It was published on June 12, 2014. And the holding in matter of EFHL was in the ordinary course of removal proceedings, any applicant for asylum or for withholding or deferral of removal is entitled to a merits hearing on those applications, including an opportunity to provide oral testimony and any other evidence without first having to establish prima facie eligibility for that requested relief. And what happened in matter of EFHL was that the Attorney General actually vacated matter of EFHL and remanded the case back to the immigration judge to move forward on the case. The case had been, after EFHL was published, it had been administratively closed, and the Attorney General sent it back to be reopened, remanded and reopened, and to move forward on the case. And so now we do not have the precedent in matter of EFHL, which states that a case does not have to show prima facie eligibility in order to get in order to have a merits hearing. And technically, if a judge feels that a case is not prima facie eligible, could summarily dismiss the case prior to a merits hearing. And so at a minimum, this is just a word of caution to provide detailed answers on the form I-589 at a minimum so that when you get to your master calendar hearing, there is a threshold finding of prima facie eligibility. If you aren't doing detailed answers on your form I-589, include a declaration to, again, address the prima facie eligibility.
Great. And that, Renee, that's a helpful a pointer that goes to several questions that we've gotten for not just defensive cases, but also affirmative asylum cases, where the guidance in the past has been to prepare, a bare bones application to get the clock started or meet the deadline. But should we be articulating all of our various social groups in the application? What should we be doing if we have filed a bare bone applications in either venue, defensively or affirmatively?
So if you've already filed a bare bones asylum application, our thought process right now is to supplement those applications prior to the next master calendar hearing with, at the very least, a well-detailed declaration or possibly an amended application that has more detailed answers to the questions. And I state that because I think that's a minimum, because I don't know that you necessarily, and this is a conversation we've been having internally as well, as whether you have to file, the full asylum application with all exhibits, and I don't read EFHL or the vacation of EFHL that way. I read it as showing the minimum of eligibility, which is, showing prima facie eligibility. And that doesn't mean that you have to have everything ready to go 2 years in advance. You just have to articulate enough to get past that first look of the judge.
Yeah, great. And if I could chime in with another question that we're getting, as we're talking about these practice pointers and throwing the kitchen sink in, we're getting questions about very practical pointers of keeping briefs brief for the judges, or the adjudicators we've heard before, and how do we balance that? Like, should we still be keeping our briefs as brief as possible, or should we be briefing all the issues thoroughly?
I think it's an and, right? So right now it's untested. But what we know is that we need to be providing all of the relevant facts. And so, of course, writing a 100-page brief is going to be unwieldy and may be ignored by, I think most immigration judges will say they'll still read it, but it may not be as effective. I think trying to be as brief as possible with making all of your arguments is that fine line, that needle we all are going to have to thread moving forward.
And perhaps also considering what components of your brief could you trim back on and simply reference more quickly and cite to the exhibits. So perhaps you don't have a long 4-page articulation statement of the facts. You trim that down and you're just citing repeatedly to the declaration for the pieces that you want to direct their attention to.
Yeah, I agree completely. So I'm gonna move on to another practice pointer here, and that's in, again, that matter of AB, that AG session seems to hit hard in matter of AB, which is credibility in the Real ID Act. Definitely become familiar. We have been embracing Real ID for some time now. However, there's definitely an undercurrent in matter of AB that encourages the immigration judges, if they choose to really think about whether these claims are credible. And so on that, I think one thing we would say, or I would say, and Kirsten agrees with, is nerves can get the best of any of us. And when you're in immigration court, or even in an interview with an asylum officer, it's an extremely stressful situation for our clients. And so making sure we're mooting our clients as much as possible so that we're sure she's comfortable with with what she has said in her declaration, that she understands the court process, that she understands what's going to happen, and is as comfortable as she can possibly be when she gets to immigration court or to that interview. I'd also add, if you're not already doing it, which I hope you are, but if you're not, we really need to be thinking about FOIAs and FOIAing for CBP for the I-213s, which are the statements that our clients, if they're picked up by Border Patrol, it's where Border Patrol is putting what they say, or the interpretation of what Border Patrol thinks is said at the time that they are interviewing them. And the I-213, there is case law out there. In fact, some recent board precedent that reinforces that the argument by ICE in front of the immigration judge that the I-213s are inherently reliable. And so knowing what's on that I-213, what might be argued in court, and how, and making sure that clients are prepared to explain that in court is super important.
And also FOIAing, somebody's giving a great add-on, FOIAing for USCIS officer interview notes, where affirmative applications have been referred to the immigration court. So that's a great additional tip.
Yes, thank you. As well, we'll talk about country conditions. That comes up as well in matter of AB. There's a footnote 9, where AG Sessions discredits in matter of AB some of the country conditions evidence that she used in her case, stating that it was a news article. Well, we all know that we sometimes that's all we have to go on for other than the Department of State country conditions. And certainly, I believe in matter of AB, the undercurrent there was to only rely on the Department of State country conditions. However, I would state we've been noticing lately a lot of analysis around what country conditions reports, especially when it involves the conditions for women, how they have changed between last year and this year, and within previous years actually, and this year. And that is to say that if you look at, for example, the 2016 Department of State reports, you'll see that there's a very long explanation of the conditions of women within countries. And it goes further than saying there's a law on the books against domestic violence. It says, okay, well, how is that law treating women, and how is the government treating women under that law? This year, in the 2017, especially for the Northern Triangle, it's just a statement of law, that there's a law on the books, and doesn't go any further to explain how the federal governments in those countries are treating women under those laws. And so I think there's an argument, or I would posit that there's an argument to use 2 different years of country conditions to state that the reliability or unreliability of certain years from the Department of State country conditions report. So, and then last but not least on this slide, you're going to have to, we talked in the beginning and we'll stress it again, internal relocation is going to have, you'll have to address that in your briefs and in more detail than probably in the past. And I stayed here in the government response. And I think, again, everything dovetails with each other. So if the country conditions for a woman are not safe, then internal relocation is not safe as well. And then from that flows a lot of sub arguments around the ability of abusers to find their partners in the country and to continue the cycle of abuse.
And if your client is a mom and the abuser is the dad, then let's flip the coin and use the country's laws, if there are paternal rights and access laws, to your favor here, that you cannot extricate yourself in many places from your abuser, no matter where you go. Sometimes you're not allowed to move without permission of the parent, unless you're going to leave the other parent, unless you're going to leave the child behind. In Honduras, you have, in many countries, you have to have both parents' permission for a passport, right? It's like no exceptions. So look at those areas too of what is the not just the social structure of the society, but the legal structure of the society that traps women in relationships, and also truly precludes them from being able to effectively internally relocate and extricate themselves from the persecution.
So I want to just make one last point before we move on to other questions, which is a lot of what we're saying here and a lot of what our internal advice is, we're making a record. We're setting the record. We're putting forward every best argument possible at this point, because most likely there are going to be judges that will be persuaded, but there are going to be other judges that won't be persuaded. And in doing this, you're making the record not only for an appeal to the Board of Immigration Appeals, but setting the foundation for an appeal potentially to the circuit courts as well, where if matter of AB isn't revoked before that happens, we may be presenting these cases in order to get better law out of the circuit courts.
Yep, great. So we have a few minutes left, and you all have really great questions. So maybe we'll try to go through a couple of very quick, more procedural questions, and others that if we don't get to, talk to your Tahirih mentor attorney, contact us afterwards. If you want to brainstorm some thoughts about trying to establish nexus, or how do you show nexus for some of these groups or grounds. But Renee, does the AB opinion overrule circuit case law, for example, in the Ninth Circuit or in other circuits where it appears to be contradictory? No, right?
No.
She's nodding. She's shaking her head.
No, it doesn't. I mean, the circuit court will always trump the Board of Immigration Appeals or the Attorney General.
So we should be able to argue.
Correct.
And you should argue strenuously where you have if you have directly contradictory circuit case law, or even case law that is arguably, in your favor, where AB attempts to not be in your favor, please do go to that circuit law. Yep. In your circuits. And I would argue, because I'm in favor of the kitchen sink model, where I would also argue persuasive authorities in other circuits as well, if it really does go to the point that you're trying to hit home. One other sort of procedural questions. When you talk, Renee, when you were talking about matter of EFHL, and this is a bit advanced, so certainly talk to your mentor attorney more about this if you're concerned, but does the case of matter of FIFI help in the gap left by EFHL?
Yes, it actually does, and that's really impressive, whoever asked that. Yeah, I didn't go that route because of, that is very advanced, but yes, and you should argue that, and that would be what you'd want to put forward.
Great. There's a very simple question about whether the slides will be available, and we will put them up on our Pro Bono e-library. If you don't have access, please feel free to reach out to us as well. But if, no, go ahead. Sure. We have a few questions about nexus, and particularly on religious grounds. So in cases of religious persecution, is it still necessary to show that the government condoned or was helpless to protect from the persecution?
I think it's unwilling or unable. Right. I would argue that first. So yes, you'll have to show that nexus, but you're arguing that the standard is unwilling or unable, not condoned the persecution.
Yeah. So you always have to show nexus and failure of state protection, inability to internally relocate, all of those things, regardless of whether it's a social group ground you're arguing and or a religious ground of persecution that you're arguing.
Right. And just to add to, I mean, I stated like it's unwilling or unable. I think that's important because we see it also in the Asylum Office guidance, this incorporation of condoned or utter helplessness, but that's not a statute. That's not what the statute says. And so I think making sure we're sticking to what the statute says is super important.
Great. And we just have a couple of minutes left. There is one question going back to religious being thinking creatively on whether there's religion-based grounds. So things like, forced pregnancies, forced miscarriages, forced pregnancy terminations, how we might establish nexus to those, because it may not be inherently obvious. And I raise those examples of facts to look at to see if you have a religious argument, not to say that you always will. So that's important, is you're applying your facts, the most robust facts that you can gather from your client, and with as much corroboration as possible, to the law, to make your arguments. And when you're looking at nexus, I would just, in the minute that we have left, to look at the, you peel back the layers of what was actually happening in those moments, right? So that goes back to interviewing your client and how you're preparing your filings, to find whether there were nuggets of facts that help establish nexus, things that were said or done that bring nexus. So with that, it leads me to what the last point we want to leave you with, and thank you all for joining us today in this very brief hour to talk about a lot of important issues. Too much, in fact, to try to tackle everything at once. So we are planning a series of webinars this summer to go through various aspects of litigating domestic violence asylum cases in light of matter of AB. The next one, as I mentioned, will be next week, and it is on trauma-informed interviewing to try to get those rich facts that you need to make some of these creative arguments. But we will also have later this summer, stay tuned for invitations for webinars focused specifically on how to put your filing together, what to include, what not to include, and then also how to prepare and walk into court or to your interview and build your record for not just that hearing, but any potential appeal you may be doing or responding to down the line. So with that, I see that we are, oh, and one more thing, we have so much we're working on. Also, we are working on currently a model brief that is a bit of a kitchen sink brief that we hope to have available very, very soon. And we will circulate that and put it on our pro bono e-library. That is not intended to replace what you're doing, but is intended to help flesh out some of these ideas for arguments that we talked about today, so that you can use it as you need to help lift arguments and tweak them and apply them to your case. And that has a lot of this case law included in it. So with that, we thank you so much. If we didn't get to your question, please feel free to reach out to us. I realize that we do not have our email addresses on here, but you can reach out to us at Tahirih, Kirsten P, K-U-R-S-T-E-N-P @tahirih.org, or Renee C @tahirih.org, RENAC @tahirih.org, with any follow-up questions. And please feel free to reach out to your Tahirih mentor attorneys on your cases as well for follow-up questions. Thank you, everyone.